Welcome to Mindset Matters, the official podcast of Oregon Realtors. In this podcast, we dive deep into the secrets of top-performing agents, market trends, strategies, tips, and tricks that will transform and elevate your real estate career to new heights. Follow or subscribe today, and stay tuned for a podcast that's not just about real estate. It's about mastering the mindset for success. Good morning, podcast listeners. Welcome to Mindset Matters. Well, with all of the uncertainty in the world, we know one thing is for sure: death and taxes. So today we are fortunate to have Greg Harris with us. Greg was educated in Oregon, graduated in 1978 from the U of O School of Law. He has practiced in Portland since 1980. He is a native of Salem, Oregon, right here in beautiful Salem. His practice emphasizes business matters and transactions, succession and estate planning for closely held businesses and their owners. Now, lawyers are our friend, and when it comes to estate planning and representing clients that may hold their properties in estate, you want to make sure you do everything right when you're representing those clients. Today, Greg Harris is going to tell you everything you need to know about how to represent clients that hold property in a trust, should be holding property in a trust, or you may be taking on a listing or helping a buyer purchase a property where someone just died. So, Greg, let's jump right into the pleasantries of death and taxes, death and trust, however you want to couch it. What are the number one things our realtor members should know if they're going to take a listing that is either held in a trust, should be held in a trust, or perhaps someone they're dealing with the child of some of the owner of the property who may soon be close to death?
Let's start with the easiest part.
Let's do that.
A lot of real estate that we're dealing with is going to be held in a trust. The one thing I want everybody to remember, if you don't remember anything else, if you're dealing with property that is held in a trust, you want to get a properly executed certification of trust signed by the current trustee, notarized. That's what you need. Once you have that document, you can rely on that. A very good, and I apologize for the boingy.
Was that me? Okay, I'm sorry,
me.
Ben. Did you hear that?
Anyway, we'll try and minimize the annoyances today. And remember, the biggest annoyance is it's a lawyer on the phone. Anyway.
Which one, me or you?
No, me. You're good. But the point is that if you have a certification of trust and present it to the title company is satisfied. The chief counsel of a very good title company here in Oregon, Chicago Title, once told me, Greg, ignorance is bliss. Once I have that properly executed certification of trust, I'm good. And in our practice, we do a one-page. I've seen multi-pages. So the first thing you want to do, if the property is held in the name of a trust, and I'm going to talk about how it's titled in a minute, you want a certification of trust. You have to have that, because if you don't, you're going to get to closing and things are going to go kaflooey.
And the way they can learn if a property is held in trust is check the title report, because it would be recorded in the name of the trust, even if the trust is Susie Jones. It's her. Got it.
That's right. The other thing I learned very early in my practice was trusts don't own property. Trustees do. So you will see on the deed a properly recorded deed. And once in a while they sneak through and they let them record a deed that isn't proper. But it's never going to be the Jenny Pecula Trust. It will be Jenny Pecula, trustee of the Jenny Pecula Trust. That's how title in Oregon and most states is held.
And usually the trustee is the authorized person to sign on behalf of the trust?
Well, and that's the trick. So two things. That trustee, in order for us to transact real property, needs to have a certification of trust signed. Why? It's a 1 or 2 page document that summarizes. Otherwise, we have to record the entire trust and all the recording fees. So you need a certification of trust. It's a statutory document. There's actually a statute that specifies. And if, for those of you keeping track, let me find the statutory site. It is ORS 130.860(9).
Oh, we already know that.
860 sub 9. That's the certification of trust form. That's what you want, or something similar to it. The reason is, even if Jenny Pikula is named as the sole person, Jenny Pikula, trustee of the trust on the deed, when Jenny goes to her reward and I take over as successor trustee, I'm not suggesting that I do so, then automatically the successor trustee steps into that role. Sometimes you'll see lawyers that say Jenny Pikula, or their successor in trust, trustee of the, but you don't need to. Automatically, a successor trustee, after a death, can execute a certification of trust, which has to be notarized, and then you can act on that. By the way, notarization is necessary because it is going to be recorded. And that's why we notarize stuff, really.
What if it's not easy to determine who the successor in trust is?
It's going to be in the trust document. But if you have a certification of trust, you don't have to go look at the document. You can accept it on its face. If it's wrong, that ain't your problem. That's going to be the beneficiaries going after an imposter, if you will. But I've never really seen that occur. So does that answer your question?
Yeah, but if it's wrong, it could hold up the transaction.
If it's wrong, you betcha. Yeah. And the reason if it's wrong is if somebody steps in as an imposter, like a squatter, if you will, then you got a problem. I haven't seen that happen. Theoretically, it could. So if you want to be super safe, you will want to see the trust instrument itself. But I don't want to make a real estate person into a lawyer.
Right.
You can hire lawyers. You can get lawyers. It might be helpful to go to the lawyer who is representing the current trustee and get a certification of trust from them. And they will then look at the trust document and make sure it's right. And by the way, I need to do a footnote here. Historically, lawyers and real estate people have been like elephants and tigers. They hate each other. As a lawyer who does this stuff, I need you. I rely on high quality real estate people to get the deal done. You find me buyers. You iron out problems. You do what's needed to be done to get the deal done. So real estate people are crucial to the practice of real estate law.
Wow. So it sounds like you're saying our members bring a huge amount of value to any transaction, particularly one where a trust lawyer might be involved.
Absolutely. You know, the problem is, and for those of you who've been around a little bit, lawyers have a bad habit of trying to get in and take control.
No.
I don't need control. I just want to get the deal done. You're doing the hard part. You're bringing the parties together. You're getting the transaction done. Don't ever let a lawyer screw it up. Okay?
I think this is the best message. The most important message they're going to take from this podcast are the words you just spoke.
Thank you.
Thank you. That was really nice to hear. And I agree with you wholeheartedly. Everyone has their role in a transaction, and you just clearly delineated what a lawyer's might be versus a real estate professional.
So, you know, trusts are a pretty easy answer. Certification of trust. Once you get that signed, notarized, get it to the title company early. Title company may, if they see a problem, you want to know about it early so you can fix it.
Is that a document that the realtor should get signed, or should they have the client's attorney and the client get it handled? They just take the doc once it's completed.
I'd have the attorney do it. You got enough to do without trying to get a certification of trust signed. Plus, now you're blending into the practice of law and you don't want to go there.
Right.
Have them go to their lawyer and get a cert of trust prepared. And then if there's screw up, you get to call the lawyer a dirty name like defendant. No, just kidding. But, I'm not. But in essence, let the lawyers do their job.
Yeah.
If we ever get to it, we can talk about transfer on death deeds. I've seen too many do-it-yourselfers screw that up. It's cheap. It's easy. Get a professional. I don't do my own electrical work. And in our practice, we lose about 5 clients a year falling off ladders. So, and this is a side note, Don't get on a ladder.
Yeah. Good advice.
What you pay the guy or lady to get up on the ladder to clean the gutters, what you pay them is exactly the same as the copay for the ambulance ride to the hospital when you fall off. We usually 5 clients a year die falling off ladders. I've got one who is lucky to be walking 2 steps up on a 5-foot ladder, trim. He fell. They have 2 rods in his spine. So, end of sermonette.
Sounds like a perfectly good reason to tell your partner, sorry, I can't do that. We're going to have to hire someone.
That's right. No.
Okay.
Cheaper, easier. My wife threw away my ladder. Okay?
Good to know.
So, let's get back to how real estate is owned. The trust thing, simple. Get a certification of trust and you're off and running. But what about other sort of ownership things like individual ownership? We can talk about in a second. But ownership by an LLC, very common these days, or another entity. But LLCs are very common. They're a really good vehicle to own real estate for a lot of reasons we can talk about. When the the owners of an LLC are called members. When a member dies, now it gets complicated, okay? 2 questions you have to ask. Number 1, was the LLC a single member LLC or a multi-member LLC? If it's a single member LLC, we got some issues if that single member dies. If it's a multi-member LLC, the second question you need to ask is, who has authority to act on behalf of the LLC? And that means getting a lawyer involved, maybe, to see who has the authority. Most LLCs, if they're drafted by a lawyer, will have an operating agreement. An operating agreement for an LLC is like the running rules, like the partnership agreement or bylaws, a partnership agreement for a partnership, bylaws for a corporation. The operating agreement lays out the operating rules for an LLC, who can do what. The Limited Liability Company Act in Oregon, ORS Chapter 63, has a lot of statutory defaults. Those defaults can be undone in the operating agreement and in what's called the Articles of Organization. When an LLC is formed, Articles of Organization are filed with the Secretary of State, in our case, Oregon. One thing I learned getting ready for this presentation is, in a multi-member LLC, any member has the authority to transact real property, right? So if Jenny and I and 3 other people own an LLC together, I can run off and sell our real property and never tell Jenny. What? Yup. For example, there was a really snazzy hotel down on the riverfront near John's Landing, right? Everybody remembers it. There was a real snazzy bar that everybody went to. All you guys are too young. Way back when. And all the waitresses were beautiful, and they wore these lovely danskin outfits. We used to call it the land of danskin, all right? And it wasn't doing well. And so one of the members of the LLC that owned the hotel and the restaurant filed bankruptcy for that entity. And everybody freaked, because what does bankruptcy do? It triggered all their guarantees, it triggered all the mortgages, and it went all the way up to the Ninth Circuit Court of Appeals. And they said, yep, one member of a multi-member entity has the authority unless you limit that.
Which would be in the operating agreement, right? Because that seems contrary.
To limit a member's ability to transact real estate has to be in the Articles of Organization. You can put it in the operating agreement too, we do. But if it's not in the Articles of Organization, they have the legal right to do it. If it's limited in the operating agreement, that means the other members have the right to sue that member. But meanwhile, they've sold my hotel. Okay. So this actually, the preparation, and I have an outline if anybody's interested about it. But when we prepared this to teach other lawyers about it. And that was the big aha moment for me. But I digress. When you're dealing with an entity that owns real estate and they're selling the real estate, and that entity is an LLC or a corporation, you're going to want to make sure that you've got all the owners online and with you on that. Because frequently, title companies will want all LLC members to sign off on the sale or the purchase or whatever transaction.
What if the operating agreement, and I know we're going down lawyer road rather than, this will be important because a lot of properties are owned in an LLC, so it'd be good for our members to have a basic understanding. What if the operating agreement clearly delineates which of the members of the multi-member LLC has the authority to sign and purchase property contracts, not even just purchase property, whatever, on behalf of the LLC, there's one of the members that has the signatory authority.
Right. So the real question that Jenny's suggesting is, do we need to start looking at operating agreements? And it's probably a good idea to get a copy of the LLC's operating agreement early and have somebody point, okay, here's where it says this person has authority. Here's the person who can. And if not, to get that in writing so you know who you're supposed to be dealing with, because you don't want to go all the way down the road, get to closing, and then all of a sudden blows up. Most of the time, I like to have the operating agreement to the title company early so they can see that and then get feedback from my title officer or their legal department on what do you need, what do you want. If they're nervous, they're going to want all members to sign. If they're comfortable, they're going to say, oh, okay, I see Jenny's got authority to sign on behalf of the LLC. That's fine. So you're right. You want to look at that stuff or at least be aware of it as you move forward to make sure who you're dealing with has authority to do the transaction you're talking about. And the earlier you know that, the better. And if you've got a problem, I like knowing problems early. I don't like learning problems.
Right. Not at the closing table, for sure.
Exactly.
Since in every real estate transaction, there's a buyer and a seller. So on the selling side, if the property is in the LLC, the listing broker has to do their due diligence to make sure they have the right people signing and that sort of thing. But what about on the buyer's end? If a buyer's agent is representing a buyer, they bring the buyer to a property that's held in an LLC. What should they do as far as due diligence on behalf of their buyer client?
Very similar. You're going to want to make sure that the seller that the individual signing on behalf of that entity selling has authority to sign on behalf of that entity. You may want all the members of that selling entity. If I'm the buyer, I want everybody signing off saying, yeah, it's okay to sell this, because I don't want to get involved in a claim later. Once I've owned the property, I put my money in, I own the thing. Now all of a sudden there's litigation involving me.
Yeah.
And that can lock you up. So
what would a legally proper way be for the buyer who's writing an offer to sign, or have the seller? Would it be if they're dealing with one person from the LLC through a listing agent? Would it be that person's name on behalf of the LLC, or that's going to depend on who has the authority? If it's the entire LLC, all members, do they just put the name of the LLC, or do they have to list every member of the LLC?
Okay, in a listing agreement, I think I would feel comfortable with one person on behalf. So it's going to be Gregg and Jenny LLC, an Oregon limited liability company by Jenny Pakula, its authorized member. Mm-hmm. For the listing agreement, that might be okay. Mm-hmm. But at closing, I'm going to want all the members to sign an instrument indicating that it's okay to be selling the property. Unless
there's clear documentation that's got it.
Okay. And by clear documentation, I mean, I've heard from the legal department at my title company that, we'll issue title insurance based on that, because that's where the hang-up's going to be. So I get to know the lawyers at the title company really well, and make them my friends, because title companies in general and legal departments there specifically pull thorns out of my paw on a regular basis. We've all been through that, where you catch things you wouldn't have caught because of the title company. Think about the East Coast of the United States. They don't have title companies. You just close property. A couple lawyers sit down and close it in the lawyer's office. And my brother happens to lived in New England, and he had a huge problem with a right-of-way easement for a driveway because nobody caught it. Here, we've got title companies. We get title reports, even trios that give us an indication that there may be an issue or not. We're so far ahead. So the quicker you can get to the issue of who's got authority to be the seller here, the better off you are.
Sounds like a good first step if you're going to list a property.
Yeah. Oh, yeah. Find out. You're going to want to look, when an LLC owns, it's always good to know who's responsible for it. And is there an operating agreement that I can get so we can get it into eventual closing? The sooner you get that, the better off you are.
If there is an LLC, there's an operating agreement, right? Or not necessarily.
He takes a big breath. It depends. Every lawyer I've ever dealt with that does LLCs, me included, will do an operating agreement. Some people who do their own LLCs, because you can go online and file an LLC in about 10 minutes. Just fill out the form and bonk, and you're an LLC, right? So you don't need an operating agreement, and sometimes there is none. When there is no operating agreement, now the statutory defaults apply to how the LLC is to be operated. And I will go one step further. Anytime you have an oral agreement, okay, you really have two agreements. What I said we agreed to and what you said we agreed to. Lawyers are writers, okay? We like written. That's why now you'll hear verbal. I used to get yelled at in law school. Verbal is either written or oral. Verbal now in parlance means oral. But yeah, you don't need technically an operating agreement, a written operating agreement to have an LLC. Really good idea to have. And even in a single member LLC, we do operating agreements. Yeah. But sometimes, I just heard it was a good idea on a radio show, so I made an LLC. Did you do an operating agreement? What's that? Okay. So sometimes yes, sometimes no. That's what.
So you're saying you can do it, but your evidentiary paper trail will be non-existent, and it's going to be a tough battle. If you don't.
I will go one step further on do-it-yourselfing. Somewhere on a YouTube video, there's a video on YouTube about how to take out your own gallbladder. Okay. All you really need is a bottle of cognac and a steak knife, right? Just, and it's here, right? No, I'm sorry, it's over here. Wait. So there are some people, there's in a commercial I've seen, I thought it would be easy. Some people want to do it themselves. Okay. But in our experience, it's so much more effective and cheaper to get things done properly. That's why I hire real estate agents. I don't want to sell the property myself. You find better buyers. You find me more money. You get problems solved. I can't do any of that. We literally had a client who was selling a house by themselves. Somebody knocked on the door. Mom was home alone. This individual came up and beat mom within an inch of her life. Okay? We don't do for sale by owners, guys. It's just not in our DNA. People don't realize the jobs that you do and how significant your work is. That's why you're worth your commission. Don't ever feel otherwise. And this is
wow. This message could not be timed any better for our members. And I agree with you completely. And now we need to make sure they can understand what you're saying and articulate what you're saying and internalize what you're saying, because you're
the right. Most important thing, and I joke with young lawyers about this. Young lawyers, go to work for a firm and they're billing at a certain rate and they go, oh my God, I couldn't afford me. The trick is you have to be very comfortable with the fact that you're worth what you're charging, or don't do it. Get out of the business. The reason you're in that business is you're good at it and you're worth it. Everybody charges, right? Listen, when was the last time you went to Safeway and walked up to the lady in the front with a package of hamburger and said, It says $5.85, but all I have is $3. Will you take $3 for the hamburger? What does the lady at the counter say?
No, but you can walk out the door with it and I won't be able to call the police.
That's a different, okay, don't start me on that. But basically, the nice cashier is going to say, if laws were properly enforced, do you want to put it back or do you want me to put it back? Retailers have taught us that what the price is on it is what you're going to pay. Do you want it or not? And oh, by the way, this is a relatively recent development. In the 16 and 1700s, you walked in with your beaver pelts and you bartered for goods. And somebody in the 1700s in New York City said, why don't we try price tags, right? So a modern equivalent of this is, have you noticed that car dealers are saying one price? And they're trying to make you sound like, my mother used to burn these guys to death, working them to buy a car, right? Is that the best you can do? I used to come.
It's a sport. That is a sport.
That was sport. Now dealerships are going, no. But it's the same way with us. I charge X percent. This is my commission. You want to use me? This is my commission. I will turn over heaven and earth. I will make things happen for you, but this is what you're going to pay me. Don't want to pay me? Okay. Go online, have a good time. But we're providing services and we get to get paid for it. And the quality clients that we seek recognize that and are happy to make payment because we make things happen for them. Don't ever forget that. End of
so true. So see, listeners, this is a 2-for-1 podcast. Not only are you learning about death and taxes and transfer of property, but you're also receiving affirmation of why articulating your value. It's a no-brainer. You do so much. When you have a lawyer up there, who's very self-serving.
First, you have to be comfortable. Yeah. Anybody ever train a dog, right? The first thing you have to do before you train your dog is you have to be comfortable asking that dog to do that, right? And so we have to be comfortable that we're worth it. And we are. You are. Yes. Don't ever feel that you're not. And don't let anybody tell you you're not.
And those
are not your clients. We
100%.
Literally have a letter we send to people called the Upon Reflection letter. And it says, Dear client, upon reflection, we're not the right lawyer for you. And you need the opportunity to go find. Same thing with real estate. Okay. I mean, I hear these online things, right? Okay. You want to do it online? Fine. That's not who our clientele is. Our clientele needs our specialized services and we're worth it. Okay. I'll leave that at that.
Your point made and agreed 100%. But it's the same thing for lawyers, and you nailed it. You have a lot of other lawyers that do the same thing, competitors that do the same thing you do, and I could probably go find someone cheaper, but you do get what you pay for, and it's important.
I will also. There's online stuff, and if you want to spend $200 for your entire estate plan online, okay, I'm not going to tell you not to.
Yeah.
But I'm in the middle of fixing documents of a very nice new client who came to me because she didn't know how to pick the choices they gave her because she's never done estate planning. I wouldn't do my own dentistry. Okay. I'm sure I could actually send away for wooden teeth. Good enough for George Washington, good enough for me. But again, it's what you value.
Right. And it's not talking someone out of it, but it's explaining to them why they should come to you rather than do it online. And same with our members. This is why you hire me to help you sell your home or find a home. Same thing on your end. This is why you pay good money to have the properly executed trust documents. And
right. It pays off. And the real bottom line is, people, I was on a golf course once and somebody said, can you summarize what you do in one sentence? I said, sure. What do you want to have happen? And it's the same thing in any business. In the real estate is I want to find a quality buyer that will close and the deal will stay closed. That's what I want to have happen. And that's what the real estate agent's job is. You find me quality buyer. You take care of the transaction, you shepherd the transaction all the way through, and you get it closed. That's a big deal. That doesn't just automatically happen. Amateurs, first timers, do-it-yourselfers, good luck. But if you really want something to stick, I want to hire a pro. My dad used to say the most expensive, not the most expensive, high quality is the cheapest, okay? Because you only have to do it once. So, and again, I've beaten this case to death, but sometimes I think it's important for us to recognize the value we bring.
You're so right. So back to death and transfers.
Yeah.
We talked a lot about LLCs, and there's other ways you can hold property. What is the best way? The easiest, what makes the most sense? And I know, like any lawyer, you're going to say it depends. Depends.
How come you're so smart? That's exactly. It does depend. And here's what it depends on. What do you want to have happen? All right. What kind of property is it? Where do you want it to go? Give you an example. I've got a number of clients who have these jewel boxes full of the most beautiful commercial properties you've ever seen in your life. What do you want to have happen? I want my kids to inherit them. I want my kids to carry this on. Okay. Let's see. Now, if we just put all the kids on title, we're done, right? So I got 5 kids, 5 different owners. Is that going to work? Maybe not. Here's why. When you have 5, and one of when we do these kind of presentations, the one thing I got to warn people against is what I call naked co-ownership. And that means just 3 people on a deed. Oh, my kids, because when we sit with clients and we say, do your kids get along? And there's this pause. Yeah, mostly. Danger, right? And it's not just your kids. It's your kids' spouses, okay? It's your kids' kids. It's Mr. Know-It-All at the gym who thinks he knows more than your kid does about stuff and tells him to do it this way. There are all these outside influences. When you have common ownership, tenancy in common, right? Remember what we learned in real estate school. That means any one owner really controls. So if 4 out of those 5 kids want to do something with the property and the 5th kid says no, you ain't doing nothing. Moreover, anybody ever heard of the right of partition? The right of partition is a statutory right that says any co-owner of real estate has the right to force a sale and get their money out at any time. It is statutory. Anybody got a pencil? ORS 105.205 to 105.405. ORS 105.205 to 405. Read it sometime. It will make the hair on the back of your neck stand up. It says that any co-owner can bail at any time. And if you don't pay me what I want, I get to go to court and either force a partition of the property or force the sale of a property. Good luck. Bye.
And is that, I'm sorry to interrupt, but I just want a clarification point. Is that only if the property or the deed is held as tenants in common, or does it matter the ownership? Can any co-owner do exactly that?
Generally, it's tenants in common.
Got it. Okay.
So
it matters what you put on the deed. It matters how you hold title and the restrictions there.
Exactly. So when you say what's the best way to own real estate, let's go through a quick list. What are we talking about? We talking about your personal residence? Mom and dad on deed should be just fine, right? Because what do I want to have happen? If I fall off the face of the earth, I want my wife, who is unfortunately can't hear me. She went to the store. She rolls her eyes and just leaves. I want my wife to automatically own it if I die. Husband and wife on a deed is what in Oregon is called a tenancy by the entirety. It's a survivorship deed. And it means at the moment of my death, my wife becomes the sole owner of the real estate. All I have to do is record a death certificate and we're done. That may be fine if that's all I want. But what if I own a commercial property and I want it to go to those 5 kids? But I'm nervous about, I just heard about this right of partition and, one of my daughters-in-law sort of pain. And so I don't really, then an entity owning the real estate with management provisions makes really good sense. The favorite entity for the ownership of real estate is an LLC. There are two reasons for this. The first, by the way, LLCs were created in Wyoming in, I think, the 60s, maybe the 50s. But a limited liability company actually is copied, European companies started that sort of thing. A limited liability company is an entity. It's a separate legal entity that has limited liability like a corporation, but its ownership is taxed like a partnership. And that's beneficial because for tax reasons, owning real property inside a corporation is a nasty thing. And we call it a lobster trap. Owning real property inside a corporation, easy in, very hard coming out, because there's a whole bunch of taxes that are going to be applied when you take that property out of corporate solution. It isn't the same with an LLC. So again, all you need to remember about an LLC is better for tax purposes. The second thing about an LLC is it's fabulous for fractionalization of ownership. Okay. So I can create an LLC, drop my properties into that LLC. Some people create separate LLCs for separate kinds of property or separate properties. That's beyond our scope today. But in the operating agreement, and oh, by the way, when I file the LLC articles of organization, I'm going to specify that no individual member can sell or transact real property without authority from the LLC as a whole, okay? Not unanimous, just by vote of the LLC. That's important for the lawyers listening.
So to have a legal LLC, I just want to make sure I understand one point we talked about earlier. You said you can start an LLC without having an operating agreement, but you can't start a legal LLC without the Articles of Incorporation.
That's right. The Articles of Incorporation is what you need because it's a creature of state law, like a corporation. So anyway, inside that operating agreement, I'm going to form to put all my real commercial properties. I'm going to put all kinds of management provisions. I'm going to put in, okay, my son Paul, who's really good, okay, he's going to be the manager. Everybody else is an owner, but he's a manager. And he can't be removed unless 3/4, 68% vote to remove him. 1. 2, if there's a dispute, there's a dispute resolution technique. If my pain in the neck daughter-in-law wants out, I'm going to have a put option or a call option to buy out the pain in the neck and get rid of them, right? All that can go into the LLC operating agreement. It can also provide when my kids die, my grandchildren can inherit, or the remaining owners can decide. If somebody dies, we can either buy them out or let their successor in. All those kinds of fun dispute resolution, succession issues that can all go into the operating agreement. And so you can fine tune what you want to have happen. So the answer to Jenny is, what's best? How do you best hold real property? It depends on what it is and what you want to have happen to it on a certain event. For example, if I become incapacitated and I'm not managing, can't manage anymore, who should? For commercial real property and multiple properties, an LLC is sort of the preferred method, again, because of the taxation issues coming out.
Whew, so all of this being said, when one of our members represents a client, and the client says, okay, I want to buy 123 Main Street. How do I hold title? Our member should say, call an estate planning attorney to their client.
Call a good real estate lawyer. That's right. And there are lots of them in town. I know tons of them. Sometimes when I get calls from people with questions, if I don't know the answer, I act more like a travel agent than a lawyer. I will send them to the right person. And there are a lot of them. Yeah. In our practice, we do real estate, but we don't do land use. So there's some really excellent land use lawyers that we refer to. Likewise, disputes related to real estate, homeowner situations, homeowner associations, easement problems. There are a lot of really good lawyers, a number of them that we like to send work to who do fabulous jobs there. Yeah. But we can assist the client in deciding on some of that by asking about 5 important questions.
Mm-hmm. You help them navigate. You're not going to be the expert in every area.
Can't.
You're going to refer them out to who?
I know that I know nothing. Ask my wife. She'll tell you.
Oh, yeah, they for sure will confirm that, won't they?
Thank you.
Partners, spouses. Okay, so a lot of legal details. So
Sorry.
no, it's really important
By the way,
because,
when we're ready to wrap up, give us about 10 minutes notice because we want to remind everybody about the 3 things we want you to remember from this presentation.
okay, so let's talk about a couple more things, then we can get to the wrap up. And then we'll hold a subsequent podcast because there's so much information and details that's really important. And we don't want to make our members experts, but we want them to be able to recognize when they need to hire an expert, when they need to advise their clients to hire an expert, or themselves personally if they're looking at their own purchases. So what happens if someone passes away and one of the heirs or children or whoever may be, the executor, the lawyer, calls the realtor, probably a family member, because maybe it's not gone to probate yet, calls and says, hey, I want you to list my mom's property. They passed away. We want to get it on the market and sold. What's the first thing they should do?
First thing they should do is, how is it held? Is it held just in mom's name? Likely you're going to have to do a probate. And a probate is nothing more or less than a judicial process of submitting the will to the court. It's a court case. They then appoint a personal representative, the executor, who has authority under the statute to transact real estate owned by the estate. Now, even if there isn't a will, you still do a probate. It's called an intestate estate without, testament, the Latin word. Intestate means without a will, but you still can do a probate. That's the first step. Probates are, everybody says you got to avoid probate. Somebody wrote a book in the 50s about it. The only downside with a probate is time. Courts used to take about a month to get everything going. Now it can take 3 to 6 months because the courts are so backed up and, staffing and all that other junk. So probate can take some time, but probate is the gold standard for transacting real estate owned by a decedent, someone who died. What'll happen is, if there's a will, chances are in the will, it will say who the personal representative is to be. If it's without a will, anybody, usually an heir, can petition the court to be named personal representative. Once that you file that probate, and you need a lawyer to do it, unfortunately, but once you file that probate, then you want to get issued what are called letters testamentary. It's a 1-page court document that appoints the personal representative. That's your gold standard. We talked about the certificate of trust. The letters testamentary give the personal representative the authority to transact real property, and off away you go. So before you could list the property, but before you can actually do anything with it, you're going to have a probate started and letters testamentary issued. We used to be able to get letters testamentary issued in about 10 days. Now it can take a month. So that can slow things down a little bit. My partner, Mackenzie Hogan, does our probates and does a fabulous job of them. And he can give you horror stories, but he can also give you the insight and to assist in getting that going. There's also been a really big development with trusts related to probate. It used to be that if you didn't retitle your assets into the name of the trust, and it's still true, having a trust document is meaningless unless assets are loaded into it. Well, how do you load in assets? With accounts, you retitle the account in the name of the trust. With real estate, we actually record a deed from Gregg individually to Gregg, trustee of the Gregg Harris Trust. Okay, we record that deed. Now it's properly titled. But what if I die before that deed got recorded? In the old days, you'd have to do a full probate. Pain. Now, the Oregon State Legislature just passed a statute that will allow you, if you have a trust and what's called a pour-over will, which is a will that says, oh, by the way, if I die and stuff isn't in my trust, put it in the trust. It's called pour-over, pouring it over. Any competent attorney doing trust work will automatically do a pour over will when they do the trust. The new statute says that if that's the case and there's property out there in Gregg's sole name, then you can use a small estate affidavit, now called a simple affidavit, to transfer the property into the trust and get it sold by the trustee. That simple estate affidavit, you have to wait 30 days after death, but it's like a one-page document, and it's so much simpler than having...
Hence the name. Simple affidavit, hence the name.
It's a simple estate affidavit. Here's the little downside, okay? This is why you'd use a lawyer. Yes, you can use a simple estate. By the way, simple estate affidavit's been around for a long time. It used to only apply to real property of $200,000 or less and personal property of $75,000 or less. That would include bank accounts. So very limited. I mean, think about it. There are very few properties, unless it's bare land or a partial interest around here that's $200,000.
Yeah.
But so it allows, if you have a pour over will and trust, allows you to use the simple affidavit. But here's the downside. The simple affidavit, the person is not called a personal representative under that. They're called the affiant. And the affiant can only facilitate the sale, meaning you have to have all heirs sign off. Well, if it's just a couple kids, big deal. But if you got 5 or 10 heirs or you got problems, it's not easy. But it's a whole lot better solution than it used to be. So now we can do deathbed trusts and a deathbed pour over will and know that if I can't get everything transferred before mom dies, I can use a small estate affidavit to do it.
So, there's so much information.
Sorry.
The biggest takeaway for me, for our members, is to have a trusted lawyer partner as part of their team.
Have somebody you can call and ask. It's easy. But that's, one of our big 3.
Yes.
Don't be afraid to call a lawyer and say, here's this, and this. What do I do? Or what should I do? Or what would you recommend? Or should this person come down and hire you to assist in getting this straightened out? That's really one of the main points, I think. It's just, there's too many weirdnesses. I'll give you an example, unless, Jenny, do you have something else?
No, go ahead.
An example is a transfer on death deed. Oregon was one of the first states to have a transfer on death deed, which is basically a beneficiary designation for real estate. A TOD deed simply says, and it's in the statute, I'll give you a citation to it, it's ORS 93.948 to 985. 93.948 to 985. And what Chapter 93 says in that TOD deed says, all you have to do is designate, when I die, I want the real property to go to Jenny. Jenny, you're loading up on my property today.
Excellent.
You record that, boom. As soon as I die, they record a death certificate, title goes into the beneficiary's name. Couldn't be better, right? Sort of. Here's a couple. And by the way, every year at the probate seminar that we go to taught by the judges, they beg us, please don't let people do their own TOD deeds. They screw them up horribly. Here's the problem with it. Now, a TOD deed works wonderfully, except for a couple problems. Here's the first problem. To get it through the legislature, the sponsors of the bill had to promise the banking lobby that banks would have an 18-month period to make claims against the property in the case of a TOD deed. What does that mean? That means for 18 months, title company ain't going to issue title insurance because they don't know if there's a potential claim out there. We used to solve that problem with indemnities, where the heirs would give an indemnity to sign an indemnification agreement to the title company. Some title companies are saying no to that. So number one, make sure that if I name a TOD, I've put a TOD together naming beneficiary, can they hang on to the property for 18 months? Okay. Maintain it, pay the payments, all that other stuff. 1, 2. The perfect situation for a TOD deed is 1, maybe 2 beneficiaries. If you have multiple beneficiaries, you're going to have problems getting everybody, perhaps. We've had it. Again, 5 kids. 1 kid said, I'm not indemnifying the title company. I don't know the title company. We couldn't sell it. Couldn't do anything with it for 18 months. And then once we got it out 18 months, that one person was still a pain because now they're a naked co-owner. Remember that story? So you got to be careful with it. Third problem, the other benefit of a TOD deed is if you want to change your mind, you can. So once you've recorded it, you can change it. You can also sell it, and the TOD deed is not a cloud on the title. So there are benefits to it, but it's not a do-it-yourselfer. You've got to look at the situation and have an experienced attorney help you draft it, implement it, and administer it once it's done. But that's an example of just doing some forethought. The last time we taught this, one of the realtors raised their hand and said, "Oh, I did it. I heard about it on radio. I did it. It worked perfectly." We stopped for a minute and said, "Were you the sole beneficiary?" "Uh-huh." "And did you do an indemnity?" "Oh, I signed a lot of papers, probably." "Okay." But you can't rely on title companies accepting indemnities anymore. Title companies are afraid of one thing. They're afraid of getting sued. So they don't want to get sued. So they're going to do whatever they can to prevent that, including asking you to hold them harmless. Because an indemnity says, I become your insurer. We don't give out indemnities easily, and we shouldn't. But when it's time to sell the property and that's all we got, and we got to do it, we have to do it.
So while it's very clear these type of things should not be do-it-yourself, I get it. Is there a threshold price-wise? I know you talked about the small estate where it wouldn't be unreasonable for someone to do it themselves, because now I know it goes back to the value, articulating your value, get what you pay for. Many times, I am sure our members will hear, I can't afford an attorney.
And you're asking an attorney to do this. Isn't there some simple little toothy thing I can do without a dentist? Really? Maybe with a paper clip or a pencil eraser, I could get that tooth back in and maybe glue it in and it'll stay. The only fair answer I can give you is sometimes you can't afford not to use an expert.
The answer is no. No, there is no.
I wish.
There's no threshold.
But I'm not in the business of telling you what something's worth. Okay? I shop at Costco and I shop at Saks. Is Saks even in existence anymore?
I don't know.
I shop all over the place. My wife makes me buy $300 pair of shoes once in a while. Not very often. All right? So it's a question of what you value. If you're saying, this is simple. Yeah, Greg, but I can do this myself. Okay. I'm not saying don't. I'm just saying when you do, be aware that there may be other consequences.
Yes.
And maybe they never come to bear and I'm all wet. Okay, great. I'm not in the business of telling people what things are worth. Mm-hmm. I'm in the business of helping people who want to be helped. And that's okay.
Go in with your eyes wide open.
If you can.
Fully informed, and make your decision based on all facts.
Yeah.
And be willing to take the risk if you choose to.
And if all you say, geez, I don't want to spend a lot of money. I just want to spend $200. Okay. That's okay. It's fine. I'm not gonna.
It may cost you more than you thought in the end, but
maybe not.
Maybe not.
Maybe not.
It's a gamble. So.
Yeah.
Oh, as always, Greg, so much great information. We could do a number of these podcasts on so many different topics, because I know once you answer a question, then we go down the next rabbit hole, all related and all very important, but it just makes me realize how complicated and nuanced these particular transactions are, especially
they can be
involving a estate. So what parting words would you have for our members today? If potential client calls them and says, come listen.
Number one, get to know a lawyer you can call when situations arise that you have questions about. Number two, in the case of a trust ownership, get a certification of trust. Number three, in the case of an entity like an LLC owning it, get the organizational documents and the operating agreement if they exist.
Got it. Easy. Important, easy steps. Yeah. And then make your decision from there. Talk with the title company, talk with the lawyer. Yeah. Thank you, Greg. Thank you so much. It's great to see you. It's great to hear all this information and great reminders. And we'll look forward to bringing you back as a guest.
Anytime. Happy to do it. And thank you for your time.
Thank you.